there has never been a trial on any of the issues in this case. And that's what I don't think the court has the ability at this point to say we're gonna cut off discovery and limit it to this when there's never been a trial. And I think
Today's courtroom clash pits Veronica Shire against Andrew Goodrich in a heated Butler County hearing. What starts as a procedural motions argument quickly spirals into a battle over discovery, depositions, and evidence from a previous Texas case. Stay tuned because strategy matters here. Subscribe now for more intense courtroom breakdowns.
Veronica Shire versus Andrew Goodrich, 2025 DM 245, Butler County District Court. The petitioner appears in person and with her attorney, Ms. Huntington. The respondent appears in person and with his attorney, Ms. Gehring. We are scheduled for a motions hearing. Let's see. It really is sort of a motion in limine type of issue in terms of the extent of evidence that can be submitted that was previously submitted in the Texas courts. And Ms. Gehring is somewhat new, not as new as she was previously, obviously, but she needed time to examine the case and the Texas situation in order to evaluate what she believed was relevant and necessary from the Texas case. And there's a legal argument with regard to whether or not the court can find some basis for estoppel or re judicata or anything of that nature to suggest that these matters shouldn't be fully relitigated in Kansas. And then additionally, there was an issue with depositions and in-person appearances. And I don't know if that's been resolved or not. So, Ms. Gehring, I'll let you apprise the court as to what needs to be heard in your view and who has the burden and what you intend to establish this morning.
Your Honor, we do not have agreements on the depositions. We don't even have dates. And so, Your Honor, I think that needs to be decided today, how we're going to do the deposition of my client. I cannot get the petitioner to agree. We agree to a date, and then she won't agree if we don't get a date for my client, but then we can't agree on whether it will be in person or by video. So we need to determine, I guess, one, if my client can appear by video. I believe the burden is on the petitioner. It's her motion and her request that he have to appear in person. You know, I believe our request is that my client be able to appear by video. I set forth in my response that was filed yesterday the law that allows that. It's under, I don't know if you want me to go ahead and argue, if you just want me to answer what I think the issues are. Then the next issue, Your Honor, is whether or not they can limit discovery. I think that needs to be heard also. Mom is trying to limit what we can do in discovery, which, Your Honor, I think this is premature. I think we should be able to conduct discovery fully
Judge,
after discovery.
Judge, this is my motion, and I feel like, I mean, she's arguing her motion.
Okay, that's fine. That's fine. All right. Go ahead and argue your motion.
All right. What I wanted to say first,
but I thought I had said previously, discover, when we continued the case and sort of reopened discovery, I thought what I said is discover whatever you want, but that doesn't mean that you're going to be able to admit it in trial.
You did say that, Judge.
Advise yourself as broadly as you need to focus on, you know, what you think is important to establish at the trial with the time that you have to do it. Go ahead and explore it all, but that does not mean that the court's going to necessarily hear it all. But okay, So Ms. Huntington, please argue your motions.
Okay, Judge, what I wanted to say at the outset is, after much discussion with my client, we are withdrawing our motion for him to appear in person for his deposition. In fact, we don't believe we have time at this point because we've not been able to agree on dates to get those done and appear for trial on time. We have trial set the 1st of April. And so we are withdrawing, taking his discovery deposition altogether.
Okay.
So my only motion,
You're going to take it, you want to take his deposition, but you don't want to, but you
no,
don't.
I'm not even going to take a discovery deposition.
Okay. All right.
And with regard to the motion on limiting the scope and duration, Judge, without belaboring the whole thing, it's what is proportional to the needs of this case and what is impacting the child's life at this point. Spending time in a deposition, I have no idea if counsel is wanting 6 hours, 8 hours to spend with my client, badgering her and berating her about things that happened 20 years ago. Judge, I just don't think that that meets the needs of this case. It caused unnecessary expense. These parties have argued those same things in Texas and ended up with agreements. They had an amicus attorney make an arbitration decision. All these things have already been discussed. They're not impacting the child at this time. There are no allegations of anything currently going on with regard to these allegations in the pretrial of my client alienates the child, is erratic, drinks alcohol. That is what I'm trying to avoid, Judge, is delving into things that happened years ago. My understanding is the respondent has a criminal history, but we're not interested in delving into that because it's not relevant and material to what Your Honor has to decide in this case. And that is what is in the child's best interest based on all the facts of what is happening to the child at this point. So all we're really asking for, Judge, is maybe just an admonition. Let's keep our eye on the ball here. What are we trying to do? Do we need to go back over these things from 20 years ago? And then some sort of limit on how many hours my client has to sit and appear for a discovery deposition that is probably 2 weeks before trial. And she'll turn around and testify again at trial. Judge, I will close on that. And I mean, that's all we're asking for. I think the court has the authority under KSA 6226 B and C to protect, if you will, provide some protective orders to limit the scope of discovery if it's just cumulative harassment or has no purpose to get us to a resolution in the matter that's before the court. Thank you, Judge.
All right. So Ms. Gehring, it sounds like you can skip over the personal appearance for deposition.
Thank you, Your Honor. The frustration I have with this is this is the first time I'm hearing that by counsel, and we have been trying for over a month to get a deposition scheduled for her client, and then they keep saying, "Well, they tell Your Honor, we don't think depositions are necessary." I've heard that by counsel multiple times, but if you're going to take my client's deposition, then I'm going to take your client's deposition, and I want your client to appear in person, even though we don't think they're necessary. So it's been this long fight about this. And I can't ever get counsel to agree to a date. And now that we're a month out and probably going to have a difficult time finding dates because they haven't agreed, and now it puts me in a position. Now they're trying to push to go to trial, but now at the last minute, we don't need a deposition. But so I'm really concerned about the ability now to try to find a date, because had counsel told me this before, we had planned, Your Honor, from the last hearing, I had asked counsel, we were set for trial on today and tomorrow. So let's do your client's deposition on Friday. And she says, well, I'll agree to that, but then it has to be stipulated, well, then your client has to come in person and have his done. So all along it's been, we had that date suggested, but now, Your Honor, I still would like to do that. I don't even know if I can get a stenographer available tomorrow to do that. But now then we've got spring break and we've got to try to find, which I'm out of the office, a date to do this. So I really feel like, I don't know if this was done intentionally or what the purpose of it is, but it feels like, to me, Your Honor, had this been figured out and communicated earlier, we could have got a date. Now I'm concerned we're not going to be able to get a date. So I think we need to figure that out today, Your Honor, for the petitioner's deposition. Your Honor, regarding this motion limine, Your Honor, there has never been a trial on any of the issues in this case. And that's what I don't think the court has the ability at this point to say we're gonna cut off discovery and limit it to this when there's never been a trial. And I think under Kansas law, the court has to, it's what's in the best interest of the children when there's been no evidentiary hearing. So counsel that keeps saying, well, in Texas, there was this, that, and the other, there was never a trial. There was never, and the case was dismissed. So, Your Honor, I don't think you're bound by anything in Texas when that case was dismissed. Furthermore, Your Honor, I think for the court to get a full picture of everything that's going on, you have to have somewhat of a historical view on what's happened and how that may affect the child. The court can determine at the time of trial whether or not things are relevant for purposes of that hearing. But Your Honor, to come in and say right now before we even go to trial, you can't ask any of these questions because we think they're too remote in time. Your Honor, that's not for the petitioner to decide. It's for the court to decide at the time of trial whether it's relevant. And Your Honor, we under KSA.
Now, the courtroom debate gets technical, but extremely important. The respondent's attorney argues discovery cannot be restricted because there has never been a full trial on these issues. Legally, that's critical. Without discovery, a party may claim unfair limitation on preparing their defense. Should history be examined when deciding the child's future?
KSA 6226, we can do discovery into anything that's relevant to a party's claim or defense. So that's a broad scope. And they can't come in and limit it just because, Your Honor, I think what they're trying to do is they are concerned about what we're going to get into historically with the petitioner, and they want to try to keep it out on the outset. We are entitled to do discovery on it. She can make her objections during the deposition. Her client can answer them. And then at the time of the trial, Your Honor can make a determination of whether or not the court wants to hear that and whether it's relevant to what's going on in the case. But Your Honor, we should be permitted to do discovery. Your Honor, it's my understanding there haven't been any depositions done in Texas. There was no hearings done on the merits in Texas. It was arbitration. It was mediation. It was all this different stuff. There was never a trial before the court. So, Your Honor, my client's entitled to his day in court. I set forth the law. Your Honor, I don't think under 6226 that there's a basis to limit the discovery at this time. And Your Honor, I truthfully think it's going to get this case in a position if the court prematurely limits discovery, the ability for an appeal if my client doesn't get the ability to fully do discovery to when he's never had a trial, and to prepare. And then, Your Honor, if the court does that prematurely without the ability to even discover some of this information, it's really limiting what my client can do at trial. I'm also concerned, Your Honor, I can't imagine that the petitioner isn't going to go historically back into some of this. And then how do you determine what history we're going to allow in and what we're not? Because what they want to do is allow in what they want and exclude what's harmful to their client. So, Your Honor, I think at this point, the court should not limit the discovery and allow us to fully do discovery. They can lodge their objections throughout the deposition. She can answer the questions. And then at the time of trial, we can determine whether or not it should be admitted or not. But, Your Honor, I think at this point, it's premature. I also think, Your Honor, after the discovery is completed, if she wants to file a motion in limine at that time prior to trial, after we've done discovery, maybe that's a more appropriate time to do that right prior to trial. But, Your Honor, I think at this point, the motion should be denied.
Okay. Ms. Huntington, can you and your client be available for deposition tomorrow?
I cannot. I advised counsel a week or 10 days ago, right after the hearing, that a PFA special setting got set that morning. I advised her of this fact. I'm not trying to, I'll find a date for my client. I also advised her that we needed to get her client scheduled because I will be out of the country for a week. And she kept poo-pooing it, saying, well, we don't know if it's going to be in person or not.
Okay.
And so that's
I'm
what
not,
led.
I'm not going to lay blame anywhere with the lack of depositions being scheduled at this point. I did not look at this case that you cited, Ms. Gehring, but I have a feeling that's a deposition of a witness, not a party. I'm concerned that civilly speaking, under civil procedure, I believe parties have to appear within the state that they filed a suit, or within a state where they're a party, in person, frankly. And I don't know that that statute's caught up with the Supreme Court rule and the ability to Zoom and all of that kind of thing. But at any rate, they've withdrawn that. So I don't need to belabor how he needs to appear in person or by video or otherwise. But let's move to the other issue. I do believe you have a right to depose the plaintiff in this matter. I do, again, if I didn't say it before, believe as an attorney who advocates and prepares and advises that you do have a right to full discovery, protective orders, perhaps on medical or private things, and things that may be totally unrelated to anything related to marriage or parenting. But at any rate, I think you're allowed discovery. I expect Ms. Huntington to make contemporaneous objections to anything that she thinks is objectionable, including relevance. I would ask that you try to find a real-time court reporter so that there can be a transcript, so that those things can be noted by the court during our trial, if at all possible. I assume that, Ms. Gehring, you pay for the court reporter, you pay for the transcript, and
Yes.
I don't think there's a party witness fee. I'm not sure whether your client gets anything or not for that. I'm not going to give a time frame. I don't think there's anything statutorily that suggests that I can do that. What I am going to say is, if it becomes pure badgering and it's clear that it's badgering and psychologically impacting your client for whatever reason, that, once you've hit that 3-hour mark, you can call my office and ask to have a ruling from the court as to any extension of that deposition. But I'm not going to say it's restricted to 3 hours or it's restricted to 4 hours. But I will allow you, if there becomes a point in which you believe there's extreme badgering and it's quite apparent that it's for purposes of not just rattling your client, but psychologically impacting her, then you can call me and I will take it up with counsel at the time. But otherwise, just make your objections, try to get a record. I need you to agree on a date right now before we go off the record.
I can start Wednesday, the 11th at 1:00.
I have a court hearing that day, so I can at 2:00 in person. I guess it's not in person, but it's by Zoom. But
is there something you could move or have somebody cover? I would really like it to be within the week.
After intense legal back and forth, the judge makes a practical move. The deposition will go forward, Objections can be raised in real time, and the court will intervene if questioning becomes harassment. It's a classic judicial balancing act. Allow broad discovery while protecting witnesses from intimidation. The pressure now shifts toward the upcoming trial.
If at all possible, especially if you're going to be gone during spring break.
I think I could do the morning of March 12th.
I can do that.
Okay.
Veronica, can you make that work? Okay.
She's shaking her head yes.
Yeah.
Where are you doing the deposition?
Yes, sorry.
We can do it at my office.
Is that all right with you, Miss Huntington?
I don't usually prefer that. Can we do it are you going to use Kelly court reporting? Could we just do it over there?
I also have to make sure I can get a court reporter. I've never done it at a court reporter's office. I mean, we usually just do it in my conference room here.
Well, I think probably, I think if I were attorney to attorney, that I'd want my client in my office, just like you'd want your client in your office. So there isn't just a sheer intimidation factor just because you're off soil. I mean,
We can do it here. That's fine.
do you have the space and
I
the
do.
ability?
Yeah.
Okay. Well, let's have it done at your office at 9 a.m. then. And if you need to start a little earlier or a little later or whatever you need to do with the court reporter.
And Judge, you will be in available that day.
Yeah,
We
let me
need
look here. Amy always responds to emails, even when we're in court. I have a Greenwood docket. I'm in Eureka in the morning. And then I have some Zoom hearings in the afternoon. It's all Greenwood Elk stuff. But I will stop whatever I'm doing and listen to your objections and arguments if it's needed. So,
Okay, so Amy will be with you in Eureka?
yes. I
Okay,
think she plans to go. Amy, do you plan to go this time?
Yes, I will be over there.
Okay, yeah. And
thank
we
you.
can give you that direct telephone number too, in case you're not catching her attention by email.
Okay.
All right, anything further today?
Not from the petitioner, Judge.
Do we need to set a pretrial for a motion in limine, or are we just gonna do this during trial?
I'm fine to do it the morning of trial if counsel's okay with that.
Well, I don't want to spend a lot of time in motions the morning of trial.
Okay, all right, then,
I
yeah.
don't mind doing it throughout the trial as questions are asked, but I want, we got 2 days. I want to get the case done. I think we're going to need the full 2 days, frankly. What does your schedule look like March 27th at 9 o'clock?
I have another PFA trial.
Okay. What about Monday, the 23rd at 3 o'clock?
Sorry, Judge, that's me again. I'm out of the country until the
Oh.
25th.
Okay. Well, then
The 30th, 31st, I have time. I don't know if that's an option.
I have a PFA trial and it's scheduled all day live and I'm not sure why. Usually,
Judge, is that March 31st, you said?
yes.
That trial is off the calendar. They've reached an agreement, but I have you out of the office as of 3:30 that day.
Yeah.
So you are available from 9 to 2.
The hearing ends with a clear roadmap. Discovery continues, a deposition date is scheduled, and any evidentiary battles will wait for trial. Nothing explosive today, but strategically huge for both sides preparing their cases. The real showdown is still coming. Like, comment, and subscribe for more dramatic courtroom stories.